We can call out them one on one. Okay. I think we can call out each one individually so that we don't have to worry about what others are thinking. And hmm? Okay, sure. Mhm. I haven't received the list, so can you please share me the list so that I can check? Okay, Radhika, you can start then. Is it okay for everyone, or do you want to see the arguments? I mean, Radhika, are you comfortable presenting the arguments in front of everyone? If you are okay, then I don't have any problem.
Yes, sir, I'm comfortable, but I've only made the memorial for one case.
Okay, no problem. You can present the argument for one case.
So, do you have my memorial, or should I present it?
Let me check. I have received few memorials. You can present so that I can check. I have received Ipsitas, and I think Danish team has already shared. Just checking about others as well. Had you written the name on your memorial,
No,
Radhika?
sir, I don't think I wrote the name.
Okay, yours is from respondent or petitioner?
So, it's from petitioner.
Okay, I think I have received it. 21 pages, right? Okay, I think we can start.
So, it's just for 9 pages.
It's for 9 pages. Shreya,
So
can you
mine
please?
is 21 pages.
Okay, okay, got it, got it. I have received one. Sure. Hmm. Sure, sure, sure. Hmm. Hmm, hmm. Okay, Radhika, you can start. Mhm. Okay, done.
Okay.
I think Aman, you can start now.
Okay, sir.
Yeah. Can you please share? I mean, yeah. Thanks.
Okay, sir. Council seeks Council seeks permission to address the bench as your lordship.
Okay.
Uh, council uh, Council seeks permission to make submissions in the court, and out of total 20 minutes, 17 minutes will be taken for arguments and 3 minutes for rebuttals. And
Okay.
with your excellencies, council seek permission to briefly state the facts.
Sure.
I am the
State.
counsel on the behalf of petitioner, and I am approaching the court under Article 32 of the Constitution of India, and I am going to argue on the first issue only. So, due to the outbreak of COVID-19 in India, this virus has challenged a lot of constitutional and fundamental rights. So, in case one, where a lot of people are affected due to COVID-19, this has led to admission of them in the Pearl Government Hospital. But due to a lot of pressure of due to admission, the government got squeezed by the pressure, due to which they were not able to perform at optimum and uh, were not able to provide basic facilities, and they also even face backlash from their frontline workers due to lack of PPE kits. In case two, where the Primary Valley Government School was closed down due to COVID-19, and all of their classes were shipped from offline to online. But due to loss of employment, loss of their jobs, of their parents. A lot of people were not able to afford the mobile phones and the internet connectivity. But even though there were a lot of problems regarding their economic basis, their headmaster have made it mandatory to do online classes, due to which a lot of students started withdrawing their admission from the schools. In case 3, due to lockdown, a lot of industries and factories were closed down, due to which workers have lost their jobs, and they were expelled because they were not able to pay rent. So therefore they decided to go back to their hometown. But due to closure of states, this has led to not able to go back to their homes. Therefore, a lot of chaos was formed, and due to which central government initiated a relief for all of them to provide shelter and food. In Saurashtra, where the government have said to provide free rations, when the workers rushed to their ration shops, most of them were denied to given rations because they belong to different states. And in case 4, where Mandra government had issued a 4-month timeline for not paying rent, where a student Sneha, due to closure of all the schools and colleges, went back to hometown. The landlord asked her to pay the rent, even though there was the 4 months timeline to not pay rent. Still she paid because there were emergency due to her sister's emergency. Then again the landlord asked, but she was not able to pay because her father has lost her job. So therefore the landlord went to high court to file a case. But there were a lot of landlords who were facing the same problem, but the court didn't entertain them. And last case, whereas the government launched an Arrogant app, where it would help in contract tracing, and which would assist in COVID-19 tracing and all, and which included collecting information, personal information. And but there was a lot of concerns regarding the safety and the working of the app, where but the government assured all the citizens that the information will be safe. But still there was the breach of but still some of the hackers, a terrorist group from Bangladesh, hacked their app, due to which a lot of the information of the people were at compromise. Council seeks permission to further elaborate their arguments and present their arguments.
So are these all petitions clubbed into one petition?
Yes.
Okay.
So, so my issue is that whether there is a violation of any legal and fundamental rights of the citizens. So, in
Hmm.
case 1, uh, looking at the Article 21, which provides that continuance of a personal animal existence is life. Right to life doesn't mean continuance of a person's animal existence, but a quality of life, and giving them opportunity to develop one's personality and potentially to live at the highest possible level. And it can be implied from Paramount Kattara versus Union of India, where it can be implied that the right to health can be enforced by a law and the state is bound to protect it. And in the present case, we can see that since the government was not able to provide proper assistance, proper PPE kits, and proper follow up checkups, therefore, and the medical and healthcare workers also protested because of not able to providing PPE kits. Therefore, it violates the fundamental right to health, which is bounded by the state to protect. And in state of West Bengal and Paschim Bengal Khet Mazdoor Samiti, the court declared that the right to health enshrined in the Indian Constitution impose an obligation on the state to safeguard the right to health of every person and preservation of human life. But in the case, the hospitals was not able to provide and failed to control the situation. And since it is the responsibility of the government to have a proper budget, and in case of emergency to provide a certain facility to the citizens, and due to negligence of the government on this side, which has infected which has led to delayed treatment, lack of proper infrastructure and healthcare system, and due to which a lot of casualties were faced.
Sure. So, dear counsel, court
Yes,
agrees that right to health is a fundamental right, and it
yes,
has been acknowledged in multiple cases by the Supreme Court.
yes,
The only issue which Supreme Court faces right now is that the COVID-19 is not a small disease; it's an epidemic. It's an unprecedented calamity which has come to the government. Government, not this government, government worldwide are not prepared to face this kind of calamity. So even though right to fundamental right, I mean right to health is a fundamental right, that does not give absolute right to citizens, or probably there are certain restrictions which can be imposed on the government as well, that on these criterias government can also fail. They are not the uh, supreme in everything, right? So because
Yes.
of this calamity, because of this epidemic, they were not prepared. I think this should be a better, there should have been better preparation, that is no denial. But whether the right to fundamental right has been infringed, that is a questionable thing.
Uh, the judge, the your lordship have a very valid point, but I
Hmm.
would like to submit that like the basic preparation and the health emergency protocols are the government responsibilities, and it should like the government allots a certain budgets and proper infrastructure. So if the government hospital has taken the responsibility and worked really well and have created a coordination, so it could be better managed. But
Hmm.
we can see in the facts that a lot of havoc was created. Even the frontline workers, doctors were backlashing them because they were at their own risk. If all of them were not at their safety, so the whole ecosystem will be collapsed. So
Okay,
a certain basic thing can be expected from the government.
definitely. Continue please.
Okay, so in case 2, we will see the right to education, in which under Article 21A, it is inserted through the Constitution 86th Amendment, whereby the state guarantees free and compulsory education of all children of the age 6 to 14 years. And in Mohini Jain versus State of Karnataka, the Supreme Court made the right to education a fundamental right, which is now as an integral part of the right to life. In Unna Krishnan versus state of Andhra Pradesh, where the right to education was given an additional meaning in the following words: a citizen can call upon the state to provide educational facilities to him within his limits of economic capacity and development. Comes within the meaning of the right to education. Therefore, it is duty of the state to take necessary action in this regard by providing all necessary arrangements for remote learning to maintain continuity of education. And now, looking at the given situation, the government have not provided any alternative method, like various alternative method, like providing any offline material to the students or any other things through which the learning continues. And
Dear Council, I have again one query, very simple query. I understand probably considering the developing country, developing state of the country, not many parents, not many children will be able to afford the laptops, probably the tablets, just to continue the digital education.
yes,
What measures do you suggest to the government so that they can continue? I mean, citizens can enforce their fundamental right. At the same time, government is not able. Government continues to have those efforts so that the COVID outbreak is not goes out of hand. So, is there any suggestion or measures you can suggest? The kind of notes you were saying that we can provide the reading material. I can see the problem which we have in front of the code, that is related to the primary schools. The primary schools is from first to fifth, which means the student will not be able to refer those notes by themselves. They need certain guidance, and that is why probably government thought they may not be able to enforce the right of education to all the people. At least to certain people they will be able to enforce those rights, right? So are there any alternative measures? Because you were saying that there are alternative measures, can you please suggest so that we can instruct the government that you should do those things instead of mandatory compliance of the digital education?
yes, Your Lordship. Some of the alternative methods that I would suggest is that since mobile phone is the only source which most of the Indians, citizens of India have, so the teachers should have the responsibility to guide their parents, or through any voice call they can uh, teach the students, and through a medium of speaker where nearby people can hear about what teacher wants to say. want to teach like the speaker, which is mainly in a locality, and through TV
Again,
channels,
the
he
risk of again the risk of COVID-19 will be there. If any teacher is going to the locality to teach the children's, the risk of contamination will be high in the children's, and we know that there were many cases where children were affected because of the COVID-19, and they were the most vulnerable class of society right now. So we cannot take the physical contact risk, right? So that is why the digital education is important. The kind of suggestion you are saying that we can impose the voice call, probably a mobile call, the numbers are not suggesting so. Are there any numbers that how many people in India have the access to mobiles? It could be a mobile. I mean, there are mobiles which are Android. There are mobiles which are uh, keyboard mobiles. I don't think they will be able to share the screen and everything. And if a person will be able to understand everything through a voice call, I don't think primary student would be able to afford that particular uh, ability.
Yes, Your Lordship, you have a very valid point. So, the only suggestion that I would like to present is that the teacher could guide the parents, and the parents could further tell their children just the education shouldn't stop, which is education, which is the priority, which will help in
How
future.
teachers are going to guide parents? This is what I'm asking.
They can make a certain rule book, they can make a certain syllabus, they can make a certain pointers, which
Again,
could,
see, the only issue in primary education in government schools are that the parents of those children are already illiterate or probably farmers, right? This is the reality of India. This is the rural India. And the problem which, I mean, the issues are coming from the rural India only. So
yes,
probably they may not be able to understand. If you are going to tell them what is 2 plus 3, they may not be able to understand, but they know the maths, but they will not be able to understand, and they will not be able to teach their children, right? So how this can be done? I understand this is one of the method where the parents are literate and they will be able to teach their childrens, but that can be done in any home. There will not be any need to go to the tuition as well, right, or schools as well, because parents are literate for them.
yes.
That is just a certificate ultimately. But I'm asking how the rural India problem will be solved without the mobile or laptops.
So if there is any easiness on lockdown, like maintaining any social distancing, proper social distancing, a screen can be implemented in a proper in a area where all students gather and where the teacher from home is teaching
Valid
and the
suggestion.
student.
Valid suggestion. Thank you.
Yes, yes, Your Lordship. And in looking at the case three, where a lot of workers were expelled and they were not given proper rations under Article 50.
Also, directly move on to the prayers.
Okay, Your Lordship. So, wherefore, in the light of facts presented, arguments advanced, reason given, and authority cited, it is most respectfully prayed before this honorable court that it may be plead to admit the matter is maintainable in law and adjudge and declare. The petitionally additionally prays that the honorable court may make any such orders or as this honorable court deemed fit and proper in the facts and circumstances of the matter, there is violation of legal and fundamental rights of citizens of India. And for this act of kindness, the petitioner, as is duty bound, shall ever humbly pray, all of which is most respectfully submitted on the behalf of petitioner.
Thank you, Aman. I have seen your memorial. I was looking at the memorial when I was looking at the screen. So I think your memorial is okay. You have made a good attempt. There are few suggestions I would give. Always try to keep the text in justified format. So if you can see the statement of facts and summary of arguments, probably the body of the memorial, it is somewhere inclined to the probably left or right. So it should be justified format. That's the minimum, bare minimum you can do. Uh, you have presented the facts in more than 2 pages, around 2 pages, which was, I guess, the mood problem as well. How many pages was the mood problem?
So it was 4 pages.
Oh, okay, then it is okay. Coming to your oral arguments, I think you have done a fair job. to be honest, and you were able to answer the queries, even though the queries may not be relevant totality. Okay, because COVID-19 situation has eased now. But yes, you have given a good attempt. There are few things you will have to keep in mind. Uh, First thing is prayer. You should never read prayer. It should be by heart,
Okay.
right? So prayer, you should always remember that you have to have prayer in your mind so that you can directly present those things in your mind. You were very good in summarizing the facts through the mood problem, right? Even though you were looking somewhere, that is fine, because ultimately you will have to see what were the main points which you will
Yes.
have to narrate to the court. But you were very good during that particular point. There were certain time where in arguments you were looking at the screen and I mean, you were just reading those. But that is
Yes.
fair because the preparation time may have been less for you. But overall, a good attempt, I would say. Okay, thank you so much, Aman.
So, and I want to ask
Hmm.
some further questions. Like, this
Yeah.
was my first moot ever,
Mhm.
and I have a moot on 8th Feb as well.
Right.
So, what are the various tips you would like to suggest in my moot memorial and arguments?
See, in Moot Memorial, I think you have included, since this is your first Moot, I think you have included sufficient number of cases. That is not going to be a worry. Two, three things you will have to keep in mind while drafting the memorial, that you cannot text an article in the middle format, right? If you have seen, Article 32 is written in middle. So either it should be, I mean, I have seen my memorials that is just left inclined, but in justified format. So that you can do. Another thing you will have to keep in mind is font has to be uh, uniform. If you can see, let me just give you a brief background. Uh, just give me a minute. I have seen some issues. Just, yeah. If you can see page number 10 of your memorial, the summary of arguments, the heading of summary of arguments is in different font than any other font for argument advanced, probably the
Yes, sir.
mood problem, right? So
Yes,
these
yes.
will make impact, and these are
Okay.
very noticeable things. Similarly, if you have seen, even the issue 1 is written in a different format than any other format which is used in the memorial. So either you
Yes.
can have the same font. If you are using times what is that,
Times New
calibri,
Roman.
times new roman, then you can keep that particular format uh, consistent in the memorial. It could be 14, 12, 12, 10, that is not a worry, but that has to be similar format. Okay, size
Yes, sir.
could vary, the style could vary, but font has to be same. Done.
Yes, sir.
Another thing I can say, whenever you are getting nervous, take some time and go slow. Don't worry about the pace. Okay. If you, how many minutes will you have in the next mood, which is your,
So it is not told yet, but
okay.
probably 10 minutes.
Okay. Just try to summarize those within 7 minutes. Okay. Prepare arguments within 7 minutes so that you will be able to answer the queries very well within the time.
Okay.
Okay. Any other questions?
Yes, sir. Any issue with my arguments? What? Any scope of improvement in it?
See, ultimately, what I would say, when you presented the first argument, na, you can relate to the facts as well. You can say that the COVID-19 had presented these many issues because there was kind of a situation through the epidemic. You have to be a balanced situation. You can consider, when I asked you the question that government was not prepared for these kind of calamities, right? You can say definitely understood, but government is supposed to be prepared for these kind of calamities. This is their responsibilities. Right to fundamental right is given with no exceptions. What is the exception? Except for the procedure established by law. Right? Article 21 says except for the procedure established by law. What is the procedure established by law? That is Epidemic Act. That's the only exception which they have. Okay. So these are the kind of things you can say.
Okay.
Rest all is good. So
Okay.
don't worry about it.
Thank
Just
you,
have
sir.
the confidence, and you will be able to do good arguments.
Okay. Thank you very much, sir.
Okay. Thank you. Who is the next? Who is next? Ipshita, are you?
No, sir. Radhika and Ruchi are before me.
Okay. Radhika?
Am I audible?
Yeah.
So actually, my Wi-Fi is not working. I'm in a hostel, so I'm using mobile data. So if I switch on the video, I think my voice would crack.
You can switch on. I mean, if that cracks, then we should be able to. I mean, at least for 1 or 2 minutes, so that I can understand your arguments. That's the only thing. The confidence. Yeah. Please.
So, right? All
Yeah.
right. Can I begin?
Yeah. Yeah.
Okay. The council seeks permission to address the bench as lordship.
Granted.
Much obliged, sir. The council is here in the matter of Manoj and others versus Union of Kedra on the behalf of Manoj and others. With due permission, with due permission of the lordship, the council would like to state the jurisdiction.
You can turn off the camera
Okay.
because
The
I think the
appellant
voice
is
is lagging.
present.
Yeah. You can turn off the camera. It's lagging too much.
Oh, okay, okay.
Tell me.
The appellant in the present case, the appellant in the present case has approached the Supreme Court of Kenya to initiate the present appeal under Article 32 of Kenya Constitution. The appellant most humbly and respectfully submit to the jurisdiction of the Honorable Court. With due permission, the Council would like to brief about the fact.
Directly move on to the
The
issues.
Council, all right, sir. The Council is presenting the case on the second issue.
Sure.
Uh, the the issue over here is whether there is a violation of any legal or fundamental right, and the council believe that there is a violation of the legal and fundamental right. Uh, it is humbly submitted that before the Honorable Court that the case highlights the violation of citizens' right in Kenya during the COVID-19 pandemic. Now, due to the COVID-19 pandemic, as recommended by the WHO as well, there was a lockdown. Now, during the lockdown, it is the state's responsibility to ensure that the fundamental right is protected. However, due to the economic challenges, students at the Primary Valley Government School lack access to online education. This infringes upon their right to education under the RTA Act and Article 21A of the Constitution. Additionally, it is the state duty as outlined in the Directive Principle of State Policy under Article 41 to provide free and compulsory education. This is being neglected, sir, and judicial intervention is necessary to address this injustice and uphold the state responsibility to ensure equitable access to education for all. So, sir, I stand here today to defend the students of Primary Valley School whose right of education is being violated. Now, these are the future generation of our country. If their right is being violated, the entire country's future is being violated. The denial to access online education for students is infringement that is also mentioned in the that can be referred through the landmark Supreme Court judgment in Mohini Jain versus State of Karnataka 1992. So over here, court held that the education is a fundamental right under Article 21 of the Constitution, and this case emphasized that denying education to individual based on their economic status violates the fundamental right to life and dignity. Additionally, the Supreme Court ruling in Uni Krishna versus State of Andhra Pradesh in 1993 underscores the state's duty to provide education as a mean to realize others' fundamental right and promote social justice. So, sir, along with the right to education, there is also a right to life that is being violated because in state of Kerala versus N.M. Thomas, it was held that denial of education due to economic circumstances perpetuates inequality. So by denying this, the state is further promoting inequality. Then the
Council.
imposition of
Uh,
yes, sir.
Council, is right to education an absolute right?
Sir, right to education is a fundamental right, and it can only be violated by the procedure established by the law. And the procedure that is like it was added later in 21A, but
So,
the right,
what are the exceptions available in Right to Education Act? Is there any
sir,
exception available?
So there are mostly no exception available. It is if the child is under from the age group to 8 to 15, he or she deserves free and compulsory education.
Okay. So does that mean that you are not fighting for the rights of children who are above 14?
So right now I'm focusing on the children on the primary valley school. This case is mostly about them. So I am right now focusing on them.
Okay. Continue,
So
please.
yes, sir. The imposition of mandatory online attendance without ensuring equitable access to technology further contravenes the principle of equality. So the thing is, when the imposition of mandatory online class, what it is doing is that since these students do not have access to a digital device, they are withdrawing from the school. So the problem is with this mandatory online attendance. At present, due to the digital divide, if online classes is not possible, the state shall ensure that offline remedial classes are taken once the situation is normal, or as recommended by the Deputy CM of Delhi, Manish Sisodia, in his interview, that these classes can also be televised in the television or
Okay.
radio.
Definitely, this is a good suggestion and
Yes,
has
sir.
been recommended over the time. But let me just be very clear that
Yes, sir.
all the education boards have different kind of educations available. Probably the syllabus is different, the mode of education is different. The
Yes,
kind of rural area teachers will not be able to I mean, if you are broadcasting any kind of educational channel in a particular decision, right? What is happening is, because of COVID, even the situation is so meager right now that rural India is not able to afford recharge their dish TV or probably anything, right? So
yes, sir.
ultimately the issues will come. The the suggestion which co-counsel or probably the previous council has suggested, that we can broadcast a screen and through which you can have the education. You also suggested probably till the time the situation is normal, then we can have the offline classes. Government is always ready for the offline classes. The only issue is they do not want those children to be exposed to such a such a disease, right? So that's the only concern government has. Government also have some limitation in the time, in the form of economic capabilities. Government's most of the resources are towards the main emergency, which is the healthcare emergency as well. People are dying on roads. So they are trying to protect them, and at the same time they are trying to protect those educations running, whoever can afford it. Okay, what if we are going to digitalize this channel? Will you be satisfied with this? So
Sir,
will that be a sufficient remedy if we direct to the government that either you can televise the news channel, sorry, a channel through which the education can be provided? Will you be satisfied with this?
Sir, this will partially solve the problem
Mhm,
because, as you mentioned, that a lot of people do not have television.
mhm.
The problem over here, the major problem is this compulsory online schooling, especially to the primary valley school. What it is doing is that since the students are unable to join the classes now, they are withdrawing from the school. So
Right.
even if the situation becomes normal, they won't be
Is
able
this a
to join
government
that.
school?
Yes, sir.
Okay.
So the major problem is first with the compulsory school, and second, sir, there can be a lot of resources, not just television. There could be they can send it through newspaper and they can send it through radio, and the education won't matter that much because it's primary schooling. Almost all board the syllabus is kind of same. It is primary schooling, so no matter which teacher teaches, the syllabus won't be the course academic is not that high level that it will have that major problem.
Definitely. Okay, move to the
Yes.
next issue now.
Sir, I was only doing the first issue.
Okay, no
So,
problem.
should I, if the lordship agrees, can I move to the prayer then?
Sure, you can move on to the prayer.
Sure, sir. In the light of facts presented, argument advanced, and reason given, it is most respectfully prayed before the Honorable Court that it may please to admit the matter as maintainable in law. and adjust and declare that the appeal is maintainable before the Honorable Court. There is a clear discrimination against the student of primary Valley Government School, that there is a violation of petitioner's right under Article 21A and right to equality under Article 14. The state is accountable for providing free and accessible education even during COVID-19 pandemic, as the right to education is fundamental. The withdrawal of student was unconstitutional and shall be declared null and void. And finally, temporarily, online schooling should not be made compulsory, and remedial classes should be provided once the situation is normal, and or pass any order that the Honorable Court may please to grant in the interest of justice, equity, and good consciousness. All of this most humbly and respectfully submitted by the counsel of the petitioner. Thank you,
Thank
sir.
you, Ruchi. Ruchi, can you please tell me which one was your memorial?
Sir, it was 12 pages.
12 pages.
Uh,
Okay.
yes, sir. It was, I think, late Droid Moot. I think I submitted
Mhm.
like that.
So you had presented it on behalf of appellant, and you told me that you were presenting the arguments under Article 32, right?
Yes, sir.
But in the memorial, it is 136.
So, Article 32 and 136.
Though both cannot be invoked at the same time.
Yes, so I think in my mood I have written 32, but I think maybe while submitting I did not edit that.
Cover page is 136. Okay.
Yes, sir,
Hmm.
I'll take a note of that and I'll change that.
Sure. Another issue was the petitioner's spelling was incorrect, I guess. Please check in the
Right.
footer. Okay, these are the minor things, but they make a huge impact. Again, the
Yes, sir,
same issue was
absolutely.
there. I mean, font was changing. In footer, it was Calibri, and probably in
Yes, sir.
the body of the argument, it was Times New Roman.
Right, sir.
Let me just see. I was unable to. Yeah, again the same issue. The alignment is not there in the statement of facts and everything. Let me see other things. You have presented only one summary of arguments. Mm, Argument one, argument two, argument four. Okay. So I don't have much on argument advanced and everything. The only thing I can say is instead of presenting those argument one, argument two, or something, you can
Yes, sir.
have, I mean, submissions is something different and arguments are some, little different. So instead
Okay.
of typing it as argument, it should have been either submissions or probably directly you were just flowing the arguments. So that could have been one thing. Now coming to your oral arguments,
Yeah.
first the noticeable thing was that you were saying sir, sir, sir too many times, which is
Okay.
not the right thing. Either you will call judge, since this was Supreme Court, you
Mm,
will have to call justice or your lordship,
mm,
something like on the similar lines. Okay.
okay.
Next thing was when you were presenting the arguments, since I did not ask you to brief the facts, you directly move on to the issues, which was very
Mm,
fine because judge asked you the same thing. The only issue was when you were presenting the arguments. For the first 30 seconds, probably 40 seconds, I was unsure on which issue you are talking about. Because while when you presented the arguments, what you said that this is
mm,
in violation of the fundamental right. You did not even quote which fundamental right initially. So when
okay.
whole background was given, then ultimately right to education came into picture. So then I realized probably you are talking about the education related issue. Okay, so this is very important that you have to, whenever you are presenting any argument, within the first sentence itself you should give them the background, which is your base, right?
Okay,
If
sir.
mandatory laptop is, I mean mandatory digital education is being imposed, that is a violation of fundamental right. You could have summarized or probably started the arguments in a similar way, or probably started in a way where you are saying that rural India is a rural country. 80% of the economy is owned by the agriculturers, right? Agriculturist
Mm,
owns this economy and they cannot afford these kind of luxuries. Laptop is a luxury in this country, right? So you can,
right.
again, the good thing was I'm not sure whether you were reading all together or what. your voice modulation was good. So you can keep this kind of pace and this kind of tone. This was very good. uh, apart from that, everything is okay, I guess. Because you had some sort of idea because of Aman's argument, so you were able to present the alternatives as well. Yeah, television's alternative was good. You had also referred to Manish Sisodia's suggestion. That is also good because those things can be presented in the code. Because one state government is ready to do that, which means other state government can also follow the same. Right? This is not a very big ask for a government just to televise education on the national TV, because they can do so with very ease. Okay, so this was good. Thank you so much. Any questions,
So,
Ruchi, from your side?
yes,
Hmm.
this is like my first mode.
Hmm.
And like I wanted to ask, like suppose I wanted to mention that article specifically when I'm citing that article, how should I like
Which
should I
article?
just put the article?
Manish Sisodia, the article you are talking about.
Yeah, yes, sir.
Okay, so what you can do, I mean, I shared Blue Book 19th edition, right? So there news articles reference is there, so you can take accordingly, because
Yeah, yes,
ultimately. Hmm?
like I did the citation blue book
Hmm?
wise, but then I'm not putting it in the state advance like over
Okay,
there we are putting.
you can say what you could have suggested, that one
Mm,
of the chief minister of states of Arkandia, I hope that is
mm,
the name here, or Kindia,
yeah.
whatever name is used for India, the one
Okay.
of the chief minister of the states of this, or probably education minister, you can say better,
Yes.
they have suggested that these measures can be
Okay.
imposed to provide the education to children. And this has been a very valid suggestion and can be imposed through those this. Okay? Because ultimately
Right.
what you will have to suggest, what court needs is, if you remember, I mean, I'm not sure if you all have read this thing, advocates are the friend of judges as well, right? They
Yes.
are someone who will guide the court as well. So that is why you just don't have to come with the problems, you always have to come with the solutions as well. That is why even
Mm,
when Aman was arguing, I just asked for the suggestions. Do you have any suggestions? Just because you have a problem, that does not mean court can grant the remedy. Ultimately what court will do, court will just fine the government. That's the only thing they can do.
yes.
But if you do not have the suggested remedies, if you can recommend remedies, that is well and good, because ultimately that is the main thing. Even if you are granted money, ultimately the rights will still be affected, right? Unless you have the sufficient remedies. So that was a good attempt, all in all.
And so one last
Hmm.
question. Like I have my Moot inductions
Hmm.
in coming Feb only. So
Hmm.
on the memorial, is there any specific thing apart from the formatting and stuff? I'll do a Grammarly and formatting check.
Hmm.
Apart from that, argument basis, like should I add more case laws or something like that?
See, what I would recommend is what you and Aman has find out. Those cases are very, very landmark cases. Okay,
Yes.
those are important. I'm not denying that, but there are few more cases which are either latest cases.
Right.
Ultimately, why I'm saying so, because these are the cases on which the right to education was Unnikrishnan, for example. That was the case on which
Mm,
right to education was kind of established in India. So
yes.
whenever you are arguing on right to education, you must refer right to education act as well. So that's the
Mm,
important thing. That is why I asked whether right to education has any exception. Right, 6 to 14
okay.
is given, but whether they have any kind of exceptions available, but that is not the case, right?
Yes.
Ultimately you will have to enforce either this way or that way. That's the mandate on government. So you have to refer right to education act, because these are the important points which you will have to follow.
Right.
Okay,
So thank you so much for your time,
no
sir.
problem. Thank you. Who is next?
Sir, I am next.
Yeah, Radhika, please start.
Sir, I'm not very sure how to seek for permission,
Okay,
but should I directly start with my arguments?
yeah, you can.
Oh, sure, ma'am. So, sir, my the issue that I have chosen is issue number one, which basically talks about the problems faced by people due to sudden emergence of COVID-19, and the government couldn't provide for proper facilities, and which led to the government servants not being able to serve the people, and they backed off because of that. So my issue is whether the Supreme Court of India has a jurisdiction. So I would like to add on to that. So an NGO filed an appeal in the Supreme Court, a writ petition for the infringement of right to life, which is mentioned under Article 21. So my issue is whether the Supreme Court of India has the jurisdiction to try this matter under Article 136 of the Constitution of India. So the Supreme Court has the right to deal with Article 136, but herein the petition was directly filed to the Supreme Court. So the Supreme Court has the right. Uh, sorry, I'm sorry, sir.
Hmm.
I would like
No
to.
worries.
Uh,
Continue. Continue, please. No worries.
Yes, sir. So the special leave petition, you can file a special leave petition when you're not satisfied with the judgment of the lower courts. But here, the petition was directly filed in the Supreme Court, so the Supreme Court directly had the right to give the judgment. So here, the question of Supreme special leave petition isn't even existing. Like it doesn't exist here.
Okay.
And also for the infringement of right to health, which is a fundamental right, the government has the responsibility to provide proper medical aid to every person and strive for the welfare of people at large, as mentioned under the landmark judgment of Parmanand Katara versus Union of India, where here where the government couldn't provide for these facilities. So there's an infringement of the right to life. And also there's another landmark judgment that there's another landmark judgment named Paschim Banga Khet Mazdoor Committee versus State of West Bengal, where there's a primary duty of the government to provide for proper medical facilities and secure their welfare, which the government couldn't do in this particular case. Therefore, it is held liable for the infringement of fundamental right to life. Thank you.
Radhika, what was your major proposition in Article 36? What I was unable to understand whether you were saying that Article 136 is not invocable in this present case, or whether the petitioner has to come through Article 136. What was your proposition? I was unable to comprehend.
Yeah, sir, I'd like to clarify.
Hmm.
The My proposition was that now the NGO directly filed a writ petition in the Supreme Court, and my issue was whether um, Supreme Court has the right to, you know, pass judgment for Article 136 over here. So when we talk about that, Article 136, you can file for special leave petition under Article 136 when you're not satisfied with the judgment of your lower courts. But here, the petition was directly filed in the Supreme Court. So the special leave petition can't be filed here because the matter would be dealt under writ petition.
Okay, so ultimately Supreme Court will have jurisdiction, even if it is dealt under writ jurisdiction or 136. I mean, most of these cases are clubbed into one case. So ultimately, this has become the writ jurisdiction only. So either way, ultimately you will have to defense. That's the only thing I'm saying.
Yes, sir.
They are coming from 32. They are coming from 136. Ultimately, you will have to defend the case. So you are agreeing with this case, right?
Yes, sir.
Okay. Now come to health issue. Yeah, you were saying something.
Sorry, sir. What?
Yeah, right to health. You were arguing on right to health. You can continue.
No, sir. I argued on right to life, which
Hmm.
was infringed here, well, because the government didn't provide for better, proper medical facilities, and didn't provide for proper medical aid to every person when there was
How
need.
right to life is affected because of this?
So, because right to life is affected here because the government didn't take proper action when the people's life was at risk, basically.
They tried to impose the restrictions, They
So
issued guidelines that everyone should maintain this much distance. They issued guidelines related to the use of mask. They imposed immediate lockdown just to ensure that there is no more uh, uh, what I can say, the COVID spread. And they immediately started testing as well. So what more government could have done, and how this is government's inaction not to perform, not to do anything.
I would completely agree with what you
Hmm.
just said, but I think the facilities that the government provided, the precautions it took, they weren't enough, and there was a need. So there was the problem that the government faced while there was COVID was that there wasn't proper medical facilities. There weren't proper medical facilities available, because of which many people died. So the government could have maintained a fund beforehand, which they would have used in the times of emergency to provide for proper medical facilities. So they lagged at some place. I would
Okay,
completely agree that yeah, they provided for
move on to
facilities.
the prayer, Radhika. Move on to the prayer.
I'm sorry, sir, but I haven't written the prayer.
Okay. I think arguments are done right now. Okay. There are very few issues, and those are significant issues. First thing, I am not convinced with your memorial at all. What is this?
I'm sorry, sir. I just prepared it in 2 hours, so
Okay, that is not a worry, but these are the screenshots you have presented, right?
no, sir. I haven't presented the screenshot, but I've done primary research, and that is
But
how
that
I
doesn't
wrote
look
it
like. I
in
mean,
detail.
I know how arguments. I mean, how the font will look, but this I have seen some. Yeah,
No, sir. I
124.
haven't copy
Chat is
pasted. Yeah,
available. There is blue tick available in the last page, if you can see. I think this is your memorial, na? 9 out of 9.
yeah, 9 pages.
Yeah,
So where's the
last.
blue tick?
I'm not the blue tick. 1:24 p.m. It is showing.
Where, sir? I'm not able to
Let me
see.
confirm with Riya. If I may be mistaken. Let me check. This was just a minute. Okay, coming to oral arguments. Radhika, there was few issues. First thing I can say, probably you were not prepared at all. So that was one of the issue. Second thing was language was too casual. My issue, my issue. This is not your issue. This is the court's issue. Okay. These were things which probably Aman and Ruchi also somewhere down the line they also included that kind of language where probably you are being too friendly with code. You cannot be too friendly with the code. You have to maintain that kind of language which is professional. The issue with the court, the issue presented in this case are these. Okay, this is not your issue. This is not even council's issue. This is not even petitioner's issue. This is the issue in front of the court. This you will have to always remember. Second thing, which side you were representing?
Sir, I was presenting the side of the petitioner.
You were presenting the side of petitioner. Your memorial says you are respondent.
No, sir. I've written petitioner everywhere.
Then why were you
Sir, I
can
was
you please share your,
defending the
yeah, you can
case.
share your screen and tell me what was your memorial. I think I'm little confused. Probably this was not your memorial at all, and I'm questioning wrong person. Can you please share your screen?
Sir, I don't think you're questioning the wrong memorial.
Okay, please share your screen so that I can check.
Just a second.
Sure, sure. You sharing screen? Yeah, please. No, I don't think I have received this one. No, 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 no. Probably I'm questioning the wrong person. Okay. Cancel it. S- I have got some screenshots as well, so probably I will check with that person. You can stop sharing. I haven't received this memorial, I think. So can you please share, Shreya? Okay. Radhika, again, there. To be honest, I am still not sure which side you were representing. Okay, that's the kind of confusion which was there in the argument. So this could be one of the point where you will have to be very clear, because you were questioning petitioners right of coming under article 136 and under article 32. So that is why I even asked what is the question here, because if they are coming through 136 or 32, you are petitioner na? So you have to back your rights, that's it. So I was confused whether you were petitioner or respondent. So that's the only thing I can say. Be clear. Okay.
All right.
uh, what I can say, just to make you clear, that even though this was not the best performance, but you can definitely improve. Just prepare more, and if you want to give your arguments again, that is also fine for me. I can have those argument after the after everyone's argument, so that if you want to give another attempt, I can definitely have that. Okay. So once I have your memorial, I will give you my inputs on memorial as well, so don't worry about that. Okay.
Okay, sir.
Yeah, tell me, did you actually prepared for this? I mean, did you seriously prepared, or was this a normal attempt? I mean.
So, to be
Mhm.
honest, it was a normal attempt.
ओके, ठीक है. So that's good ना. अगर आपने honestly prepare किया होता, then there were few concerning points, right? Then you will have to prepare more. That's the only, I think, that's the only thing I can say. But I mean, if you will prepare, you will get to know what side you are representing. You will have better clarity in your arguments. Coming to the court manners and everything, you will get to know once you read that particular, I think, moot court module which we shared, where you will have all the court mannerism as well. So you, that is very basic thing. You can read those things, and you will understand what we are trying to convey here. Okay.
All right, sir.
No problem. Good luck. Who is next?
Thank you, sir.
Thank you.
Sir, me.
Yes. Yes, Abhishek.
Good morning, sir.
Yeah.
Sir, I'm representing only one case.
Mm-hmm.
I'll start.
Sure. Let
The,
me just.
the council seeks permission to address the bench as a lordship.
Granted.
The council is appearing before the Honorable High Court on behalf of the defendant in response to the writ petition filed under Article 21 of the Indian Constitution.
Right.
The council seeks permission to begin with the statement of facts.
Directly move on to the issues.
Okay, sir. Uh, Lordship, there are two main issues involved in the present case, where I'll be dealing with only the second issue,
Mm-hmm.
which is whether there is a violation of any legal and fundamental rights of the citizen of India.
Mm-hmm.
Article 21 of the Constitution states that no person shall be deprived of his life or personal liberty except according to procedure established by law. To uphold the rights of the livelihood of the migrant workers, the Supreme Court had ordered free food, shelter, and transport to be set up in camps. Using one ration card of one state in another is not a fundamental right of the citizen. Instead, it is a system in which the administration of the ration card works. In Maneka Gandhi versus Union of India, the court noted that the procedures specified by law for depriving a person of his right to life and personal liberty must be proper, reasonable, and fair rather than discretionary, whimsical, and oppressive. Similarly, the ration card registered under one state not being allowed in another are made to avoid the misuse of ration cards. And also because different states have different administrative policies and schemes to maintain ration cards for their holders. So, these restrictions posed on the migrant laborers are proper and reasonable to maintain a track record by the by the government, and it should not be deemed as oppressive. In a suo motu writ petition of Bandhua Mukti Morcha versus Union of India and others in reference to the problems and miseries of migrant laborers, the Supreme Court of India had issued an order to all states and union territories dated 9/6/2020 to take steps for identifying the standard migrant workers in their particular states who are willing to return to their native place and prepare their journey by train or bus, uh, the process of which should be completed within 15 days from that day. The railways also provided 171 Shramik trains within 5 to 24 hours of that order to carry out that particular order. The states and union territories were also directed by the Supreme Court to provide details of all schemes present in their particular state or union territories to the migrant workers so that they can benefit from the schemes, in which also included the schemes made for employment of them. The state also directed for establishing of counseling centers and help desks to provide the migrant workers with necessary information regarding the schemes.
Dear
With
counsel, thank you for the arguments. Few issues, few questions I have. What were the main issues? Main issue was whether the ration card can be allowed interstates, because ultimately migrants worker are moving from one state to another. Uh, this is an emergency situation. Court acknowledges that, and there is no denial of that. Isn't this the emergency situation where state and the union government should come together and implement a scheme where all the ration card, I mean the person who is in need of ration should receive a ration irrespective of whether he or she has ration card?
yes, sir. Yes, Your Lordship. The court acknowledged that, and yes, the central government should have uh, set relief camps where where they should have sent free foods instead, like without even seeing if that particular person has a ration card or not. But as it was during COVID time, and total government was like the total all the offices and
You are
government.
representing central government, right?
Yes, sir.
Okay. So when central government imposed the lockdown, were they not even aware how many days this can extend? Did they not have any kind of preparation that if we are going to allow that, if we are going to lock down the whole country, what chaos will this 140 crore population will do? Ultimately, this is a country where around 40 to 50% population is below poverty. How will they survive? What were their preparations? And this is one of the preparation: food, shelter, and education. All three were failed miserably by the government, not coming on the medical aspects as well. So healthcare is again a issue. So these are the three issues which government had to take care before announcing the lockdowns, just to protect the healthcare infrastructure, right? Healthcare infrastructure is already collapsed now. What are the preparations, what were the preparations before announcing the lockdowns? This is the question. And if you are not allowing interstate ration, what is the use of then these policies? And what is the use? I understand the apprehension of misuse, but what if this is not used properly?
Sir, Your Lordship, the government did fail in maintaining the health. They did fail in maintaining the system. Uh, the COVID-19 pandemic was not the government was not ready to tackle such a big pandemic. And during when the first lockdown was imposed, it was first made lockdown was for some was imposed for some days, but with the increase of cases, the government had to increase the lockdowns, and the increase of lockdown also meant that no government employees were coming to their offices. Yes, the government did fail, but and the government should have provided free food in the shelter, but the use of ration card of one state in another would lead to more discrepancy for the government.
Council, do you
With
have data of migrant workers?
no, sir.
Okay. Do you acknowledge the fact that many of the people from Bihar, UP, or the developing states move to Maharashtra, probably southern part of India, for the employment, for the
Yes,
labor, right?
yes.
Once you announce the lockdown on 20th of March, how will they survive? Because you have already shut down all the industrial work, right? They
So,
are the daily wages. Once their daily income is stopped, how much savings would they have? That is a questionable part. Will they survive 1 month? Because the initial lockdown was announced for 21 days. Thereafter, it was extended again. So, how will they survive?
sir, so the migrant workers, as they do not have any jobs or a place to live in the cities where they were currently residing, the
Hmm.
government had the Supreme Court had issued order, and the railways had provided 171 Shramik trains for them to go back to their native places.
Hmm.
So the government did not leave them stranded where they were.
And
Uh,
how much exposure will they have of COVID? Is there any data because of these Shramik trains?
no, sir, I did not collect any data.
Okay. So, okay, let me just ask one question so that if remedy is needed, what remedies court can grant? Aadhaar card is issued by government, right? Or
Yes,
probably any voter ID or any identity card. Will you be able to issue ration to everyone who can present the ID, a government authorized ID, instead of ration card?
yes, sir. This remedy should have been, to be honest, should have been done. And instead of asking the migrant laborers
Hmm.
to come to the Russian department, social workers from the department should have gone to the uh, to the camps set up by the government to give free food to everyone, regardless if they have a card or not. And specifically in the time of a pandemic, it can also be that the migrant laborers didn't bring anything. So yes, regardless of any identification, regardless if they have any identification or not, free food should have been given to all.
Okay. Thank you, Ipshita. You were representing respondent, right?
Yes, sir.
Let's come to directly your memorial.
So the prayer.
That is fine. I have seen the memorial, so that is done.
Okay, sir.
There are common issues. I can't foresee any special issue with your memorial. So these are the similar issues where font is not same. Probably the left alignment is there instead of the justified format. See, Ipshita, your when you were presenting your arguments initially, you were going very good, to be honest, and it was one of the what I can say strongest argument when you were presenting till the time I started questioning you. The only issue which I faced was you were not even taking stand on behalf of government. You were accepting that government failed. You even mentioned that government failed. You cannot say so. What will happen if government, attorney general, or these persons are going in Supreme Court and they accept that Supreme Court failed? They never accept these things. Okay, what you can accept that there were certain difficulties. Understood? Difficulties are acceptable, but government failure, if that would have been a small thing, that is acceptable. But this is a big issue, right? So you cannot accept that government has failed. You said the government was not ready. They have to be ready, right? If I was not going into the details, but if I could have said that the COVID-19 was detected in 2019, right? Ultimately, it was detected in
Yes.
2019. First case came in January 2020 in India, in Kerala, or probably in December 19. So ultimately, you have 3 months period. What you will have to understand is you just have to go through the status of government as well, right? When you are presenting your government, you have to say rely on the epidemic thing, right? This is an epidemic. Ultimately, people will have to suffer. What you can say here, you will have to. I understand your situation where you are saying that free ration should have been available to everyone. That is the thing. But you can say state governments also have limited budget. This is an epidemic. They have to have their budget prepared for the healthcare as well. They have to have prepared for other things as well. So they cannot just provide everything for free, right? So there are few schemes which are available to other workers as well, and there are people who are protecting them. So that is why with time, because of the trains, migration trains which are available, they will reach their hometowns, they will avail their benefits of their own state scheme, so that there is no chaos, right? Because what this will do, let me just give you an example what you could have presented. Maharashtra state government, right? Probably Maharashtra and southern states may have the most migrants worker. Maharashtra may in Mumbai and probably in Bangalore, people would have been more, in Chennai as well. So what these governments will have to suffer is they will have to suffer the imbalance, because these people will take most of their rations and their own states people's rights will be affected, right? Ultimately they are also suffering. So this would create an imbalance in the state budget as well. So that you could have said. Okay.
Yes, sir.
Apart from that, your arguments were good. As I said, there were few times you said sir and then you moved to the your lordship and everything. That is well and good. I mean, that's not something that you will forget in actual moot court, because that will be a kind of moot court aura all around you, because you will be in your own uniform, judges will be kind of in the same area, you will feel that particular feeling, right? So ultimately that will be encountered. um, yes, in some cases you said that court acknowledges that you are not court. Okay, bench is court. So court will say that court acknowledges, or probably this thing, you are counsel, so you will say yeah, counsel acknowledges that. Whenever you are acknowledging any fact or query from court, you can say yeah, we acknowledge that, but this is this situation, current situation. Okay.
Okay, sir.
Overall good thing. I think it was a good attempt. Your arguments were strong. I will have to read the memorial in detail. Let me just read. I mean, these are very basic memorials. I don't think we should share. I mean, if you want to share, you can share each, uh, all the memorials in group, so that everyone have some sort of background. Because ultimately, most of them have prepared for one issue, right? So if anyone has prepared for another issue and wants to look at the another issue, they can definitely do that. So we will be able to do that. Okay. Yeah. Who is next now?
Okay. Myself will be the model.
Okay.
Councils, the council seeking the permission to approach the dais.
Yes.
Good morning to the honorable bench. If it may please, council seek the permission to address the bench as your lordship.
Definitely.
Before the Honorable Supreme Court of India, the writ petition, the PIL under Article 32 of Constitution of India for violation of any legal and fundamental rights of citizen of India,
Hmm.
and petition under Article 32 and 36 the Constitution of India as on upon the submission to Honorable Chief Justice and the opinions of Justice of the Honorable Supreme Court of India. Memorable on behalf of the petitioner, submissions by Muhammad Arif and Hari Om and Muhammad Rafi.
Right.
The I will I will briefly shortly facts about this situation of this COVID-19 pandemic disease, my lord.
Yeah, you are presenting which side?
Petitioner.
Okay. You are presenting petitioner and you have mentioned appellate. Why so?
Because I've done both the this one Article 32 PIL as well SLP 136.
So you are coming through different cases.
Yes, two different because I've made for the team. The another 136 will be represented by the Hariom, my
Okay,
council,
sure,
my lord.
understood.
The facts, as my knowledge of the upon the in January 28, 2020, the COVID pandemic was a global health crisis caused by the spread of novel coronavirus, SARS-CoV-2. The situation has likely invoked the since then. So there's critical and checks of the lost information of the reliable sources as of my last update. Here is some of the key facts of the issues related to the COVID-19 pandemic. COVID-19 has posed the significant health challenges globally, leading to the high number of infections and in some cases, severe respiratory and complications
Council,
of
directly move on to the issues.
the Article 32 of Constitution of India's fundamental rights and grants the individual the rights to move the Supreme Court for the enforce of the fundamental rights, ensuring that citizens have the direct remedies to approach the Supreme Court if they believe their fundamental rights have been violated. During the COVID-19, various issues has been arise, including concern about the violations of fundamental rights. Some of the issues related to COVID-19 and potential impact on fundamental rights includes right of health, Article 21. The consent may arise about the adequate the health facilities, access to medical treatment, and to the overall right to the health. Right to the livelihood, Article 21. Economic challenges such as jobless and business closures and many rights consent about the right to livelihood. Freedom to movement, Article 19. The lockdown, travel restrictions, and quarantine measures may impact the freedom of the movement, arising the questions about the reasonable restrictions on the rights. Right to education, Article 21A. The school closures and description of the education may arise concern about the rights to education, right to privacy, and contact tracing and civilians. Contact tracing surveillance and data collections and public health pose of many rights questions about the right of privacy. Right of equality, Article 14. The issues related to the equality distributions of sources, including the vaccinations, may be arise the concern about the right to equality. Whether these issues about the violations of the fundamental rights and warrant
How right to
inter-
equality is infringed in this case?
the prices difference on equality distributions. Vaccinations may be concerns arise and Article 92 depend upon the specific circumstances and legal arguments presented in the court.
Still not clear about the issue. How Article 14 is infringed?
The, imposing the restriction about the individual rights.
Which right?
Uh, Article equality of right of equality of
Where
individual.
is the discrimination and equality? What is the discrimination? Is government treating anyone differently?
Yes, government. The government has not. Government is treating differently in the sense like in private hospital and government hospital, and the vaccination also prices also different. Two different types of the vaccination. It is a violating of the equality.
So in government hospitals, it is free of cost, if I'm correct, right?
Government hospital, the free of cost, it has been not provided, my lord.
Okay.
The government totally has government difficulty to provide the precautions measures protect the situation pandemic. This one and purely is violating the legal and fundamental rights of the citizen.
Okay.
And in government and private hospital, after the providing the time, the hospitals authorized were unable to provide the proper treatment to the patients for regular failures checkups. And due to the sudden increasing number of the cases in coronavirus, in the cases maybe patient died a lack of the providing the proper facilities, my lord.
Right.
The, and can I move directly to the argument, my lord?
Yes, yes.
Argument the article 19, article 32 rights of constitutional remedies violation of right to health, Article 21. Arguments indicate the healthcare facilities the lacks of medical sources and other measures infringe upon the fundamental rights to the health guarantee, Article 21. The freedom of movement, Article 19. The challenges restrictions on movements, lockdowns, and quarantine measures that may be seen and exclusive and unreasonable that affecting the rights of freedom of movement. Article livelihood,
What
Art-
is right to movement? Under which article right to
Article
movement is
19.
protected?
Article 19,
Article
my lord.
19. Which Article 19? There are Article 19, Article 19 1A, B, C, D.
Article 19, 191G, my lord.
19 1G.
G. Freedom to movement.
And is it absolute right?
Oh, sorry, my lord. It's Article 19.1 A.
Okay.
I'm not sure about it, but 19.1 A, my lord. But I have not briefed
Okay.
it.
And is
Um,
it a is this fundamental right absolute fundamental right?
that's absolutely fundamental right,
This
my
is
lord.
absolute fundamental right.
Yes.
And there cannot be any restriction.
No restrictions will in the due to the corona we have the social distance restriction will be there, but due to quarantine of a long period and measures and lockdown and has been increased, it is a violation of the freedom
Okay,
of movement.
what do you want? That each person of each citizen of this country should move freely and spread the virus? That's the kind of freedom
No, with the precaution,
council seeks?
no, my lord, with precaution of scenario of coronavirus, it has to maintain the social distance and government has to provide in the weekly transportations or this one they have to make some arrangements alternately, which migrants can be traveled to their hometown and mental stress or other conditions that travel the movements has to be can be controlled into the government.
So we understand that probably the migrant workers has to be traveled so that they can move to their own country or sorry, own home state. But can we allow this to every citizen? That is not a possibility because this pandemic is spreading and is spreading like anything. So the only issue is for migrant workers, they are issuing certain trains. They have few facilities already allowed from the government. So what else can be done, and how this fundamental right to movement is very much restricted. This can be restricted with certain exceptions, and those exceptions has been exercised by government currently.
Yes, my lord. My opinion is just suggesting that okay, keeping the mind the COVID has been spreading across the global, and some measurements or weekly trains or something shelter to provided to migrants, free food, all this thing arrangement has been done till the control of COVID-19.
Mhm.
Then we can regenerate or we can replay. I mean, we can start again that normal position to back after controlling this one till time being can be slowly we can start with the migrants to move the to the hometown or few migrants can be provided shelters into the NGOs or in hospitals or schools or in the stadiums which can keep them and we can treat them. It is a duty of our
Definitely,
government.
government is already quarantining most of the suspected COVID-19 affected persons, right? Article.
This article which I'm talking about the movement of this is a bit difficult. Most of the migrants have been staying in the South India. I mean countries they panic to move to their hometown, and this is the purely violating of fundamental movement of rights.
Okay. Uh, Next.
Right to Education Article 21A, the rights are concerned about the closure of the educational institutes and its impact on the right to the education, especially on group of education, group of team. And right to privacy, the challenges intrusive surveillance measures, the data collections or contact tracing mechanisms, and that may be violated the rights of the privacy,
What are
individual
your
rights.
alternative measures? What measures do you suggest to the government instead of Arogya Setu app? What kind of measures do they take so that they can contact trace everyone?
Arrogance.
Ultimately, that's the best alternative government can find, where any affected persons can be identified within that particular area. So what are the other alternative methods which you are saying so that the invasion of privacy could not be there?
The peoples has been affected with the coronavirus, and it is data collected by the BBMP Mahanagara Paliga Setu app, and they are tracking the data and misusing and misguiding the information about an increasing number of the COVID-19. It is
Is there
purely,
any data? Is there any report available? Or this
uh,
is just a plain accusation?
it's not a plain. It has been mentioned in the Times of India. It has also in the media as a
Times of
number
India
of
is
data.
not an authoritative source.
But personal information of the like collecting the information about this one is individual rights of the
Council, do you
press.
use WhatsApp?
Yes, my lord.
So have you provided your mobile number?
Yes, my lord.
Have you provided your name?
Yes, my lord.
Do you share your photos?
No, my lord.
So do you have any display picture?
No, my lord.
Okay. Does other people share those pictures? I mean themselves.
Yes,
Most of the people
themselves.
do, right?
Most of the people do. Yes, my lord.
Yeah. So if government is planning to do something for the benefit of whole country, just to trace down those people who are affected so that others may be protected, how is this an invasion of privacy? And if this is an invasion of privacy, suggest us alternative method so that we can direct to the government that these are the methods you can impose other than Arogya Setu app.
Yes, my lord. The information, the right of privacy can be the confidential, which can be kept into the in the records, and which has not to be disclosed with the media or any other third party person.
Definitely they are not disclosing
It
it to
has
anyone.
been leaked out, and it has been number of the
Hmm.
cases has been raised with the different state and different people. That has been publicity has been done with media, and it's going to be affect to the citizens of the India.
Okay, Danish, thank you.
It's, my name is not Danish. My name is Muhammad Arif sir, because my Apple ID is Arif.
Okay, okay, Arif.
Okay, my lord. Can I
Yeah.
move to the
No, no, no. I think
press?
completed already. So I think we are running short of time as well. So let me just give
Sure.
you my feedback. There were few things you probably missed when I was talking about the Arogya Setu app and everything. There was one key detail which was available in the moot code problem was that there was some attack from neighboring countries on this app, right? So you could have
Yes.
said that this was already done and this is already done and this is kind of a threat to all the public that ultimately there all the informations will be revealed because the Aadhaar card is connected, mobile number is connected, their personal details are connected, gender and everything is connected. So
Yes, yes, my lord. Actually, I'm little bit nervous, but I have got
no
this
problem.
information. I
See,
got this information via
hmm,
internet as well as newspaper, which I
right.
tell you in the Times of India, but you told
Yeah.
that Times of India is not
See,
authorized.
that is why I'm saying. So this could have, when I said that this is not a authoritative source, what you could have said that this is not a authoritative source, but there are certain information which can be derived from the newspapers, and these are few disputable information. Court can verify those information later on. So this thing could have been done. Okay. Overall,
Okay,
this was a good attempt, and you were probably there are few issues in the memorial which I will deal once we have all three arguments. Okay.
sure.
Thank you.
Thank you.
Next, please. Okay. So Arif, I hope I'm pronouncing your name correctly. Yeah. So
Yes, sir.
yeah. So basically, the main issue with your memorial was you have included the jurisdiction of two things, which is Article 136 and
My other colleagues has suggested me that okay, Muhammad Rafi is not available, and I made for
Mhm.
Hariom, and he has some. He said I'll do, but I made according to the team
Mm.
and two cases to argue Hariom, and I think so
See,
today he
whenever
also.
you are arguing anything, so this should have been done only one. Okay.
Sure, sir.
Uh, Council's spelling is incorrect. Okay. So
Yes,
you
sir.
have to be very careful about these things. It is council, which is not a correct spelling.
Okay, sir.
Apart from that, You have referred CPC and CRPC. Was there any reference of CPC CRPC in the memorial?
No, no, sir.
But there are abbreviations used for those. So abbreviations are those abbreviations which are used in the memorial. You cannot just quote any abbreviation. Okay. So you
Okay,
will
sir.
have to keep in mind this
Okay,
thing
sir.
as well. Apart from that, let me check. Yeah. So your arguments were mainly in form of one, two, three. Uh, Whenever you are quoting any article, that is fine. I mean, you can quote the articles, but those have to be in the form of submissions. Uh, right to equality. This cannot be your submission only, right? So you can say that this is in violation because ultimately what is happening, you have written down many informations, but those are not interrelated or probably not interlinked as well. So unless and until you have that link established in the arguments, that will not have that particular impact. So just
Okay,
to have a long lasting impact on judges or probably just to engage them, you have to have those links established in the memorial as well. Okay.
okay, sir. Okay,
Yeah, so that's the only feedback I have.
okay, sir.
Okay. I
How's
think
my presentation or this one probably, sir? I mean,
it
can
was
you
good.
feel?
It was, I mean, okay. I mean, for camera, it was moving all around. So that's not even a issue. But you were able to present. That was a good thing. So overall, it was good.
Okay, thank you, sir.
Yeah. I think everyone is done now, right? So, okay. Thank you so much, everyone. Thank you. Thank you. Thank you, everyone. Bye.
Thank you so